Vande Mataram. I welcome you back to my channel, Courtroom Battles. Friends, my name is Dr. Tushar Mandlekar and I am a practicing advocate in Bombay High Court since last 13 years. I did my LLM and PhD from Nagpur University and I was a faculty at Nagpur University in LLM department 10 years ago. This channel is specifically created for the purpose of discussion on law, case laws, judgments and various other factors related to the law. If you are a lawyer or if you are an aspiring lawyer or if you have interest in law, this is the channel, friends, where you can join me and enjoy this beautiful journey of evolution of law in India in last 70 years. Welcome back to my channel, Courtroom Battles. Vande Mataram. I welcome you back to my channel, Courtroom Battles. Dear friends, today we are going to discuss a very important subject, the disposal of the criminal trial without a trial. The Code of Criminal Procedure 1973 is a procedural law providing the mechanism in which the manner in which the trials are required to be conducted on the basis of substantive criminal evidence. The primary object of the criminal justice system is to ensure that the trial has to be very fair. In India, there is an assumption that every accused is found to be innocent till he is proven guilty. Dear friends, disposal of the criminal case can be done in 10 manners. So today we are going to discuss all these 10 types of manners in which the criminal case can be disposed of without a complete trial. Normally, once the cognizance has been taken, the case proceeds and after a full trial either results in conviction or acquittal of the accused. Before that, discharge of the accused can also be made in some circumstances as per section 256 of the Code of Criminal Procedure in summons case. We all know that there are different procedures for trial prescribed in Code of Criminal Procedure. Based on gravity of the offence alleged against the culprits, the such trial can be conducted. The Code of the Criminal Procedure provides for 4 types of trial procedure. There are trial before Court of Sessions, 2. Trial warrant cases by the magistrates, 3. Trial of summons cases by magistrates, 4. Summary trials. Both the trial before the Court of the Sessions and warrant cases by magistrates are tried under the procedure of warrant cases and the remaining 2 are tried in summons cases trial. Under different circumstances, the criminal cases can be disposed of without trial. Once the FIR is registered, the charge sheet is filed in the court of law and the trial commences. But the court has got the prerogative to decide the case even before completing the entire trial and the criminal case can be disposed of without the trial. We will see all those types and manners by which the criminal court can dispose the case without the complete trial. 1. Criminal proceedings barred by limitation. When the accused appears or is brought before the court, he can raise the preliminary objection that the criminal proceedings against him are barred by the limitation under section 468 of the Cr.P.C. 1973. Now the section 468 prescribes a limitation for particular offence. The magistrate or the trial court cannot take the cognizance of the offence if the trial is commencing after prescribed limitation period. Now what is the limitation period? A. It should be 6 months if the offence is punishable by fine only. B. It should be 1 year if the offence is punishable with imprisonment up to 1 year. C. It should be 3 years if the offence is punishable with imprisonment from 1 year to 3 years. The limitation period starts from the date of the offence. So section 468 empowers the magistrate to dismiss the criminal trial on the basis of the limitation itself. Number 2, Compounding of offences. Magistrate can compound the offences as per the section 320 of the Cr.P.C. There is a list which is provided by the legislature itself that which offences can be compounded. In a case where the offence is already compounded, the trial will finish it off. So this is the second instance where the criminal trial can be finished or disposed of without a complete trial. So section 320 specifies the offences which can be compounded with or without the permission of the court. These offences are mostly of minor nature. That is injuring religious feelings, section 298, causing hurt, section 323 and 324, wrongfully restraining or confining any person, section 341 and 342, assault or use of criminal force, section 352, 355 and 358, mischief, section 320, subclause 1, gives the list of the offences which can be compounded without the permission of the magistrate. Section 426 and 427 of criminal trespass and house trespass, section 447, 448 criminal breach of contract of service, section 491 adultery, section 497 enticing, taking away or detaining with criminal intent a married woman, section 498 defamation, section 500, 501 and 502 insult intending to provoke breach of peace, section 504 criminal intimidation except when the offence is punishable with imprisonment for 7 years, section 506 act caused by making a person to believe that he will be an object of divine displeasure, section 508 of IPC 1860. Now section 320 subclause 2 gives list of offences which can be compounded with the permission of the court only. These offences are mostly of the same nature as prescribed in subsection 1, but somewhat graver, from like causing grievous hurt by dangerous weapon, section 324, 325, 335, causing hurt by rash and negligent act, section 337 and 338, wrongfully confining a person for more than 3 or 10 days or in secret place, section 343, 344, 346, assault or criminal force to woman with an intent to outrage her modesty, section 354, assault or criminal force in attempting wrongfully to confine a person. Likewise, many such offences can be compounded with the permission of the magistrate under subclause 2, section 320 of the Cr.P.C. Number 3. Accused can be discharged by the magistrate in criminal trial. Now this is the most popular way adopted by the counsels to make an application for discharge. After getting the charge sheet filed before the Honorable Magistrate, the discharge application can be filed by the accused. Section 239 provides the provision when the magistrate can discharge the accused if upon considering the police report and the documents sent with under section 173 and making such examination, if any, of the accused that the magistrate thinks necessary, and after giving the prosecution and the accused an opportunity of being heard, the magistrate considers the charge against the accused to be groundless, he shall discharge the accused and record his reasons for doing so. The Code of Criminal Procedure contemplates discharge of the accused by the Code of Sessions under section 227 in case triable by it, cases instituted upon a police report are covered by section 239 and cases instituted otherwise than on police report are dealt with section 245. The three sections contain somewhat different provisions in regard to discharge of the accused. Under section 227, the trial judge is required to discharge the accused if he considers that there is not sufficient ground for proceeding against the accused. Obligation to discharge the accused under section 239 arises when the magistrate considers the charge against the accused to be groundless. The power to discharge is exercisable under section 245 bracket 1 when the magistrate considers for the reasons to be recorded that no case against the accused has been made out by the prosecution which, if unrebutted, would warrant his conviction. The stage for discharge under section 245, on the other hand, is reached only after the evidence conferred to it under section 244 has been taken. 4. The Honorable Magistrate can give conditional pardon to an accomplice under section 306 and 307 of Cr.P.C. The criminal proceedings against an accused person come to an end if he is given pardon in accordance with the provisions of section 306 and 307. Number 5. Absence or non-appearance of the complainant in section 249 of the Cr.P.C. In a warrant case which is instituted upon a complaint, or popularly known as a private complaint, and on any day fixed for the hearing of the case, if the complainant is absent and the offence may be lawfully compounded or is not cognizable offence, the magistrate may, in his discretion, at any time before the charge has been framed, can discharge the accused. Two things are required to be considered: that the private complainant is conspicuously absent, number one, and number two, this is to be done before the charges are framed. Number 6. Withdrawal by prosecution. The public prosecutor or assistant public prosecutor in charge of a case may, with the consent of the court, at any time before the judgment is pronounced, withdraw the prosecution of any person, either generally or in respect of any one or more of the offences for which the accused is tried. Such offence must be in the nature as provided under section 321 of the code. It is found and observed that most of the time when the government is changed, it gives this pleasure to its karyakartas, and the cases against the karyakartas are found to be withdrawn by the new government. Number 7. Withdrawal from prosecution. Section 321 of Cr.P.C. The public prosecutor or assistant public prosecutor in charge of a case may, with the consent of the court, at any time before the judgment is pronounced, withdraw the prosecution of a person, either generally or in respect of any of the offences. A. It is made before a charge has been framed, the accused shall be discharged in respect of such offences. B. If it is made after charge has been framed, or when under this code no charge is required, it shall be acquitted in respect of such offence or offences. So two things: if the charge is yet to be framed, the accused will be discharged, and if the charge is framed, the accused will be acquitted. Number 8. Withdrawal by the complainant. When the complaint is instituted as the private complainant under section 257 of the Cr.P.C, the withdrawal is permissible. In a trial of a summons case initiated on a private complaint, if the complainant at any time before a final order is passed satisfied the magistrate that there are sufficient grounds for permitting him to withdraw his complaint against the accused, then the magistrate may permit him to withdraw the same and shall thereupon acquit the accused under section 257 of the Cr.P.C. In a trial of a warrant case instituted on a private complaint, the complainant has no power to withdraw the complaint. The only provision which may have some relevance in this connection is section 224 of the code. Number 9. Autre fois acquit and autre fois convict. A person once convicted or acquitted not to be tried for the same offence as per section 300 of the Cr.P.C. If the accused raises a plea that he was earlier tried for the same offence and was convicted or acquitted of the same, and that according to the principle of autre fois convict or autre fois acquit, he cannot be tried again as per section 300. The accused should not be tried usually for the same offence or on the same facts if the trial is completed or he has been acquitted or convicted. This principle of section 300 correlates to the provision in the Constitution, that is Article 20, bracket 1 of the Constitution of India. So, an accused person cannot be again convicted or again acquitted for the same offence. Number 10. Power of court to stop proceedings in certain cases as per section 258 of Cr.P.C. In any summons case instituted otherwise upon the complaint, the magistrate of the first class or any other judicial magistrate with the previous sanction of the chief judicial magistrate may stop the proceedings at any stage without pronouncing a judgment. While stopping the proceedings, the magistrate shall record the reasons for doing so. Number 11. Abatement of proceedings on the death of the accused. The ultimate object of the criminal proceeding is to punish the accused on his conviction of an offence. Therefore, the criminal proceedings abate on the death of the accused, as their continuance thereafter will be infructuous and meaningless. This position being self-evident, the code has not made any specific provision in this regard. But it is assumed that once the accused has died, the trial against him automatically finishes. Number 12, and last not the least, plea bargaining. In a criminal trial, there is an opportunity of the accused to have the plea bargaining with the state. The prosecution can bargain the sentence with the accused under this provision of 265B. An application can be made by the accused before the magistrate, and the prosecution and the defense lawyers can sit together and get the plea bargained the sentence, if already undergone, shall be adjusted in this plea bargaining. But the most important issue is that the offences to which the capital punishment or death punishment or life imprisonment or punishment more than 7 years is prescribed cannot be undergone into this plea bargaining. This is a very popular concept in foreign countries, but in India it is not that popular. So this plea bargaining can finish off the criminal trial in one stroke immediately. So dear friends, we have seen that these are 12 incidences wherein disposal of the criminal trial can be done even without completing the complete trial. We all know that more than 10 years is the average time slot which is consumed by every criminal trial in this country. Considering the huge pendency in criminal trial courts, these 12 methods can be fairly adopted by both the counsels in the criminal trial court and then get the criminal trial disposed of even without the complete trial. I hope you have enjoyed this video. If you have liked this video, please subscribe to my channel. Please comment on the comment box. Like it and please don't forget to share this. Thank you so much. Jai Hind, Vande Mataram.